Hi everyone, welcome back to our countdown of the top 5 estate planning misconceptions. Let's take a look at misconception number 4. Misconception number 4. Putting off planning for incapacity is okay because you'll have time for that later. Incapacity means that you're unable to make decisions for yourself or you're unable to communicate those decisions. Incapacity can be due to something mental, like dementia, or it can be due to something physical, like a stroke. People assume that they'll have time to sort out everything at a later date, which isn't always true. Things can happen quite quickly, like hitting a moose on the highway or receiving a terminal cancer diagnosis, and there may not be time to sort out your affairs. Why is this a problem? Nobody will have the legal right to sell your house to pay for your care, and nobody will have the legal right to pay your bills, collect your pension, or complete your tax returns. There will be nobody with the legal right to make medical decisions for you if you can't speak for yourself. Frequently, people think that their spouse will be able to take care of everything if something were to happen to them, and in many situations this is true. However, it's not true for every person in every scenario, so you need to make sure that you have plans in place. If you don't have any documents in place, the court can appoint someone to be your guardian or trustee. You'll have no say about who it is, and they'll have full control over everything you do, where you live, with whom you live, which doctor you see, which activities you do, and so on. Your money pays for the legal fees, whether you want this person in place or not. There are 2 kinds of adult guardianship, one for your money and one for personal care decisions. In either case, you appoint someone to make decisions for you if you're not able to do so yourself. However, if you don't have documents in place, someone needs to step in for you. At this point, if you've already lost your capacity, you're not able to make the choice for yourself. Every province has an office of the public trustee. Essentially, they're a government office, and this office will step in and make decisions for your finances for you, and you'll have no control over who it is. Unfortunately, the public trustee needs to step in fairly frequently, and they're a very busy agency. Also, they don't take on cases for medical decisions, so you might have someone managing your money, but you wouldn't have anyone to make medical decisions for you. So, what can you do instead? Make an enduring power of attorney. You choose someone who speaks for you, and you give them guidance on what you want them to do. An enduring power of attorney is specifically designed to take effect when you're not able to make your own decisions anymore. This is different from a regular business power of attorney, which is only in effect while you do have your capacity. With an enduring power of attorney, you appoint someone that you trust to take care of all of your financial matters, including daily activities like paying the bills, as well as larger tasks like filing your income tax or selling your home if you need it to pay for care. You can also put specific restrictions in place for something that you don't want them to do, if that's necessary. Make an advance healthcare directive. You choose who represents you. You set out your end-of-life wishes, and you can state your wishes regarding other issues such as blood transfusions, living at home, and organ donation. An advance healthcare directive is like an enduring power of attorney, but it's for medical decisions. The person you appoint can be the same as your power of attorney, or it can be someone different. You can have up to 3 people on your advance healthcare directive who make decisions unanimously. You can also include information about your preferences for living at home or living in a care facility, whether or not you want to be considered for organ or tissue donation for transplant or research purposes, and how you feel about comfort care. All of these decisions are very personal, and if you don't put information into a document for someone you trust, a stranger could end up making those decisions for you. Today, we talked about why making an enduring power of attorney and advance healthcare directive is important. If you put this off for a later date, you might not have a say in what happens. Stay tuned for our next episode where we take a look at the last of our estate planning misconceptions. Where to find us? Visit us on our website at butlerwillsandestates.com or check out our blog, estatelawcanada.blogspot.ca, Or to get in touch with our office directly, give us a call at 709-221-5511. You can also send me an email at chelsea@butlerwillsandestates.com.